Hi, welcome back to the AM YouTube channel. I'm Kathleen Jones Raya. I'm the Director of Client Relations and a Concierge Attorney. Here at AM we have a unique concept which allows when you call in to our office, we immediately put you through to a concierge attorney who will give you a consultation on the phone, answer your questions, assess your situation, and then match you with a litigator if you'd like to come in and explore retaining our firm. And when we get these calls, there are several questions we get on a regular basis that we'd like to clear up for you and answer now.
Kathleen, what happens if I'm married only for a month and I want an annulment? Can I get an annulment?
There's a misconception among people that if they've been married a short period of time, they can get an annulment of their marriage. In California, the length of your marriage is not a basis for whether or not you qualify for an annulment. If you were married for a day or 11 months, that won't be the important issue. It's the basis of whether or not you were married because there was fraud involved. If the person that you married, you didn't find out until after the marriage, really only wanted to have a green card, or one of you was under the age of 18, or there was some force used, you were forced into the marriage. All of these have a statute of limitations, which is 4 years. So again, the length of the marriage doesn't matter. If you find out up to 4 years after that there was fraud involved or there was incurable capacity, they can't have children, you can still file for an annulment up to 4 years after you find that out.
If I can't file for an annulment, Kathleen, how do I get a divorce?
Yes, so if there's any possibility that you can get an annulment, you absolutely want to file and ask the court to grant you that. But in the alternative, you're going to ask for a divorce. In California, we're a no-fault state. So regardless of whether or not you have the grounds for an annulment, if you need to be divorced from this person, California will grant that to you. It's different in other states. There are other states that require you to prove that your spouse was having an affair, and then you're reduced to having to send a private investigator out to get the evidence you need. That doesn't happen in California.
Kathleen, I've been the one working in our marriage. I've always worked outside the home, and I've built up a considerable 401k. I want to get divorced, but I want to make sure I keep my 401k. How do I do that?
In California, when you get married, you're basically creating a partnership. And California has a very strict fiduciary duty imposed on the two of you when you're married. So while you may feel as though it was all of your work and efforts that went into creating that 401k, actually it was the two of you together. And so if one of you was working and creating the 401k, the other one was either at home or at their own job that didn't have a 401k, but both of you were putting in equal efforts. And so California requires that the two of you share equally. It doesn't require that you split the 401k 50% each, but it requires that you include that in the equalization of all of the assets that were accumulated by the two of you together during your marriage.
Thank you. Kathleen, I'm getting married next week, and my fiance just gave me a prenuptial agreement that he had an attorney draft, and I'm supposed to sign it. Do I need to sign it or have someone look at it?
Prenuptial agreements can be a very good idea. It requires that each of you disclose to the other everything you own and owe, and it allows you to go into the marriage with full knowledge of what each of you are bringing to it. However, if you are handed a prenuptial agreement within a week of getting married, that's not a good idea. What you are doing when you have a prenuptial agreement is changing the way California would be taking care of your assets and your issues of support if you did get a divorce. So what you want to do if you're signing or creating a prenuptial agreement is have plenty of time to be able to review it with your own attorney, to be able to decide together what it is that you want to make different that California would do for your assets, and to understand exactly what it is that you're changing before you sign anything.
Kathleen, I've been with my husband a long time. We have a common law marriage, and I need spousal support now. How do I go about getting that?
We get this question a lot because in other states, there is such a thing as a common law marriage and it's recognized by the state. California does not. So if you've been living with someone and you never married, so that you don't have a legal document giving you contractual rights with each other as a married couple, then you do not have a right in California to get support or divide assets that you created together. What you do have is the right to go in a civil court and ask that the court find that there was a contract between the two of you that's enforceable. But it's a difficult case to prove, and it does not give you the same rights as a marriage would if you had gotten married in California.
So what kind of action would I be filing if I think of a contract, that we had a contract?
We call this a Marvin action, and it's based on a very old case with Lee Marvin, and in fact his common law wife was not successful in her request for spousal support, but that's the name that's given that type of lawsuit, and it's one that we here can handle for you, but you have to have very strong facts, and it's one that can be a difficult case to prove. Thank you for joining us. We hope you found it helpful. We've tried to answer some of the most common questions we get when you call in. If you have other questions, we have a concierge attorney here at AM that can answer your questions for your unique situation.